Welcome to Your Strata Property, the podcast for property owners looking for reliable, accurate, and bite-sized information from an experienced and authoritative source. To access previous episodes and useful strata tips, go to www.yourstrataproperty.com.au.
Hello and welcome. I'm Amanda Farmer and I have with me this week Rena Van Alst. Hi, Rena.
Hi, Amanda. How are you?
I'm doing very well. Thank you very much. How has your week in Strata been?
Yeah, busy actually. It's been quite busy for the beginning of the year, which is probably good in some ways, but it gets you back into the swing of things. But on the other hand, I hope it's not a sign of what's to come though.
Yeah, we generally find that January is a little bit cruisy, but yeah, it doesn't take long to ramp up, does it?
Well, traffic's actually wonderful. That's all I can say.
It's one good thing. Yes, one good thing.
No traffic.
Being around in January before school goes back.
Exactly.
Let's jump straight into our wins and challenges for the week. What is the challenge you'd like to share, Rena?
This is an interesting one. It's actually relating to legal fees that remain outstanding to a legal firm that had been engaged by the Owners Corporation prior to our appointment. And basically there was litigation between the Owners Corporation and one of the lot owners. And it actually ended up being a Supreme Court matter, which we obviously then just took over. And the committee then decided that the fees were actually quite high for what had been charged in terms of the Owners Corporation's legal fees. And we tried to negotiate with the lawyers by asking them if they want to have their costs assessed and even offering to pay 80% just so that they would get paid and, you know, and the whole matter would just be concluded. Anyway, so they refused to have the costs assessed and we said, okay, well, we'll arrange the assessment. And between that happening, this was before Christmas, we were served with a statement of claim. And that was served by email and registered post. And we did some investigation. I think, Amanda, I conferred with you about this. That basically, you can't serve a statement of claim by email unless the parties consent. And therefore, I think postage is assumed to be on the 7th working day after being posted. So that's not an issue within itself when you think about, you know, most companies were closing on the Friday before Christmas. So then when we got back to the office after our closure, we emailed the committee the statement of claim and they said, oh, can you send it to a lawyer? And which I did. And then after I get another call, and this time the committee said, oh, no, we want you to use this other lawyer. So I had to then retract the instructions. But anyway, they were off anyway, the legal firm, so it didn't really make any difference. But the legal firm that they're actually instructing me to liaise with, Amanda, is actually the lawyer that was acting for the owner against the Owners Corporation. So I don't know. And the lawyer's saying that they don't really have a conflict of interest. Now, I sent an email asking them to confirm that because I just don't really understand.
Yes.
It doesn't seem right to me because I don't know in terms of if they're going to arrange the assessment, they said, and I don't know if that means that they'll be able to access, you know, solicitor client correspondence. So have you ever sort of had that experience, Amanda, where someone who was acting against the Owners Corporation says, oh, that they can now, there's no conflict, they can now act for the Owners Corporation for a cost matter?
Not for a cost matter. Conflicts are something that comes up regularly in the work that we do simply because strata law being a pretty niche area of the law, and if you're in a place like Sydney where you just have a handful of experienced strata lawyers, very often we are approached by lot owners or by buildings that we have in the past acted against, and we have to really assess whether we think we have a conflict in acting in a new matter. And the way that you assess that is to think about, well, do I have or am I likely to have possession of information, documents that might be used against the other party and put me in a position of conflict where I can't properly advise my client, whether that conflict exists now or might have the potential to exist in the future. Now, your situation, this is the same matter, isn't it? It's the cost.
It's the cost aspect of the same matter.
So they're being asked to advise in respect of costs that their opponent has charged in this matter in which they were involved.
Yeah, exactly.
And I can't see how they wouldn't have a conflict.
Yeah, that's what I thought. But I mean, as a managing agent, I mean, it's not really I obviously know a bit more about this than perhaps most people do, but I don't really think, Amanda, it's really my role as a managing agent acting in the best interest of the Owners Corporation to ask the lawyer, well, you know, you're saying you haven't got one.
Yeah.
But Like, how do I suppose I've just asked them to confirm it in writing and I'll go from there. But
yeah, because I would think surely they, being the other side to the proceedings, having received correspondence from the lawyer, having been intimately involved in the proceedings,
yeah,
how would they not be in possession of information that could be to the detriment of their new client, being the owner's corporation? And how are the proceedings finished with the
they're finished.
loan?
They've been concluded. This is just the cost aspect now that remains outstanding.
Yeah, it'd be something that they would really have to think hard about. From your perspective of the strata manager, and for strata managers listening who might be in this kind of situation, and not necessarily about a cost assessment, but a lawyer saying, yes, I'll act for your owner's corporation and I don't think I have a conflict. I think as a strata manager, I would be saying to the committee, I am concerned that this lawyer does have a conflict. Having been doing this for 20 years or so, being through a cost assessment process, I can't see how the lawyer will not come unstuck, if you like, down the track, because that's what we have to think about as lawyers. Maybe not now, but down the track. Am I going to have something that I can't use because it would breach the confidentiality of my other client?
And then I have to engage somebody else then. And
exactly.
More money wasted.
Exactly. Yeah. So all you can do is warn the committee and say, look, the lawyer says I don't have a conflict. I'm skeptical about that. Matter for you. You can accept the lawyers, or you can take on board my skepticism, which comes from my experience, and choose someone completely independent.
Yeah, that's a good
or proceed. And so when it all falls apart and the lawyer down the track in 2 months' time says, oh, I've got this email, but I can't use it because it would be to breach the confidentiality of my other client. I have a problem. You're going to have to go somewhere else. You can say, voila.
Exactly.
So. Sorry you had to spend that 10 grand that you're not going to get back, but maybe next time you'll have a
exactly.
to me, the strata manager with the experience. That's what I would be doing as a strata manager.
Yeah, thanks, man. And that's what I have been doing. And I just thought, because it's quite unusual. I mean, I was actually, when I spoke to the committee member who said to me, he spoke to the lawyer and they said there's no conflict, I thought, well, that doesn't sound right. I'm not an expert, but it didn't sound right. But anyway, we'll see how it goes.
Yep, let us know.
Yeah.
All right. Well, my challenge for this week, I was recently involved in an AGM where it was proposed to appoint a new managing agent, and the motion on the agenda was to appoint the new managing agent for a term that was expressed to be until the next AGM.
No, I don't.
I had never seen that before. And usually, for those who may not be experienced in these matters, an agency agreement will say it's for a term of 1 year, 2 years, or 3 years, 3 years being the maximum that we can now have in New South Wales. But this one said the term is until the next AGM. Now, bear in mind that an AGM doesn't have to be held at a particular time anymore. A building just has to make sure that they have an AGM in each financial year.
Yeah.
Yep. So it's a very indefinite term, I would think, until the next AGM. It could be 12 months, but it could be 2 years if the AGM was stretched out.
I don't believe that's valid, Amanda, because the Act specifically says that you've got to, I probably have to check the Property Stock and Business Agents Act, which deals with this, but the Strata Schemes Management Act refers to the maximum duration of a contract. So, and that's why also, let's say it's a 12-month contract, and then you've got to give 3 months notice to the Strata Committee that it's basically going to expire in 3 months, and then they can extend it by periods of up to 3 months to the next AGM. But
that's a very good point, because you wouldn't know necessarily 3 months out when the AGM is going to be held. So you wouldn't be able to give that notice because you don't have certainty as to the expiry date of your agreement. It might be that the contract, from a legal perspective, it might be that the contract is void for uncertainty.
Yeah, exactly. I mean, I don't think that's correct at all. And I think it's funny because I'm actually noticing, I had a client contact me for another building that they own in another strata scheme. And they were saying to me, they sent me a copy of their agenda for their appointment of a new managing agent. And there was no contract attached to that agenda, Amanda, and they say, I tabled at the meeting. So maybe this is a podcast for another day, but I think it's quite common that's been happening, and I'm not really sure how people can basically make a comparison between various managers or even the one that they've been provided in the agenda if there's no information about their fees, the duration of the contract.
Yeah, you don't know what the terms are.
Exactly. Well, I don't know.
Yeah, I have been in at least 2 meetings where that's been an issue, where there has been an appointment proposed and no agreement attached. And I have urged the chairperson to rule the motion out of order. And I've referred to Section 49 of the Act, which says that the appointment of a strata manager is to be made by instrument in writing authorised by a resolution of the Owners Corporation in general meeting. So what you're actually doing is authorising the instrument.
That's right.
And how can you authorise an instrument that you don't have or haven't seen or don't know exists or don't know the terms
of? It's like
of?
passing a bylaw. That's not even attached to the agenda.
Correct.
It's saying passing a bylaw matter about A, B, and C, and there's nothing apart saying it's about the rooftop, but nothing more than that.
Yeah, exactly right. So I do think that Section 49.2 gives you that direction that you need to be attaching agency agreements to agendas to make it a valid motion to appoint a strata manager. Yeah, and I would, in the situations I've been involved in, it's been lot owners who've engaged me who don't want a particular manager appointed or reappointed, and it's been a very easy way for me to make sure that manager is not appointed because they're stuffed up. They haven't put all their committee stuffed up there by not instructing that agreement be attached, and it's the. But
sometimes the matter it's actually not the committee, because that half the time the committee aren't really aware of the legal processes that are involved in the appointment of a managing agent. Sometimes it's the other managing agent that doesn't want the incumbent to know what their terms and conditions are and what they're charging, which is pretty stupid because at the end of the day, when you get the books and records, that should be in there anyway. And also what I've noticed with some companies, and I've had to basically go back and say, you can take out all your proposals and all your company stuff and whatever you want, but you can't take out the agency agreement. I mean, that's actually part of the meeting. It was approved at a meeting. You can't just take it out of the files.
Yeah.
So.
Well, I would think anything that's been put to the Owners Corporation or the committee for consideration, whatever, it's a quote from a contractor, a proposal, a tender, they're all records of the Owners Corporation. They should all be
I think there's a real misunderstanding in terms of the law of agency, man. I think managing agents really understand that they're just the custodians of someone else's information. It's not their information.
Yep.
And it's just, I think, in terms of just when you take on new schemes, you just see that more and more. Yet there's probably only one company that I've dealt with that actually understands the law, and every other company, they just give you bits and pieces. You don't get emails, you don't get this, you get, like an export of whatever document management system they're using, and it just says so you got to open up every single document to find out
it's horrible
what exactly.
And you're charging, you have to charge the building for that work.
Yeah, well, I mean, sometimes it's hard because there's just so much, sometimes you have to charge because the time spent just trying to go through the information that's been given to you can be quite time consuming. It could be, it could be days of opening documents. And also someone said to me, because in a sense we're actually writing to an agent asking for some records that hadn't been provided. And someone said, well, how do you know that you don't have it? I said, well, sometimes you don't know until you need something that you haven't got it. So sometimes you don't know it's not there until there's a reason to access that information. So
very true. I think that's a whole topic in itself, and I'll put that on our list for a future episode. That handover process from a former manager to a new manager, that's great for our strata manager listeners to get some tips on, and also our committee members to understand what's going on in the background when you do terminate or then an agreement comes to an end for your current strata manager. You've got a new one because there's often delay, takes time for accounts to be closed and then opened.
Yeah, bank accounts to be closed, new check to the closing check to be received from the bank and all that sort of thing.
We can go through all that. All right, it's on the list.
Stay
tuned. All right, let's change track and chat about your win for the week, Rena.
Yeah, so we've had an apartment in one of our schemes that has had some water leaking into the apartment beside it, and now more recently into the apartment below. And the building manager's been trying unsuccessfully to try and obtain access, and there's a bit of a rift between this particular owner and the building manager. And so unfortunately, he said, can you please help me? I just can't get in. And the other agent also of the adjoining lot has written to me saying, we've got water penetration, our tenants asking for lots of rent, etc. So I had to end up writing a letter just to say, well, basically, if you don't provide access, we'll have to go to the tribunal. And also we gave 7 days notice because under the Residential Tenancy Act, you've got to give a tenant 7 days notice before, as a landlord, you can even go in or an agent can go in. So, so within the hour, we got a response and access was provided. But unfortunately, sometimes when there are personality conflicts or just even conflicts between lot owners and building managers, it can really affect the running of the building. Because in this case, I think there was that animosity between them, and I think that, that's why access wasn't provided, and then therefore there was loss and damage occurring in adjoining apartments and those underneath. So
often
it
the
was
case,
just good that
isn't
I
it?
didn't have to, it's just horrible when you have to go to the tribunal and lodge applications. It's costly. So it was just
and
good.
It doesn't always help things to move faster, that's for sure.
No. So anyway, that was a good win. I thought it was a quick one, actually. It was probably
And so your letter basically told the owner that you did have that right to go to the tribunal to seek an order for access, and if they don't provide it, that was your next step, and then they...
Yeah, and I also provided next to the email from the agent of the adjoining building describing, what conditions were occurring in that apartment and the fact that the owner was facing a loss of rent claim. So I tried to sort of say, well, this is quite serious now. Like, it's not just about water leaking. It's like it's really getting, and so thankfully, she agreed, and access was obtained the next day.
For those listeners who may not be across that section of the Act which allows you to go to the tribunal to obtain an access order, it's section 124 in our Act in New South Wales, and it says that the tribunal may, on application by an owners corporation, make an order requiring the occupier of a lot to allow access for the purpose of, and there's a list of a few things, but basically in your situation, Rena, it was for the purpose of allowing the owners corporation to carry out its duty to repair the common property. There, I imagine, being some failure in waterproofing.
Well, actually not. Well, I think from what I understand, it may be the renovation that the owner completed in her bathroom. So it may not even be an renovation issue. So it could even get worse.
Right, okay. But you've got to investigate that as a first step, really.
Is it an owners corporation problem or is it the lot owners problem?
Yes.
Yeah.
Yep, good point. I've recently been involved with a building where an owner was alleging a water leak within their garage and had sent pictures that there was water leaking in their garage. It's not clear whether it's coming from the slab above or whether it's coming from a pipe that's running through the garage, and then showing some damage to their goods that's happening in the garage because of the leak and some mold that's growing. And the owners corporation then proceeded to say, well, yes, we'll send our plumber in to have a look. Let us know when you're available to grant access. And this owner has, for whatever reason, known only to this owner, refused to allow access. And this owners corporation said to me, well, Amanda, what obligation do we have to force some kind of access? And I've said, well, it's water that is not affecting anybody else, unlike your example, Rena, where it's going into another lot. We've asked everyone around that garage, are you having water leaks? No. It doesn't seem to be having any impact on the common property or other lots or other people. So I said, well, why would we go to the expense of making an application seeking an access order? This owner is going to continue to suffer their own damage if their goods are being wet, of course, and subject to mold. But other than saying that, this is if you don't let us in, we can't help you.
Yeah, exactly.
That's all we can do. So good to draw a distinction between those situations where there's an obvious failure in the common property that's going to affect either another lot or other parts of the common property or get worse, and something that an owner is alleging is happening within their lot but not providing you access so that you can determine that.
You can't really do much.
Can't really do much. That's it. Okay, my win for this week, I wanted to have a chat about a 2-lot strata scheme, one owner of which has come and approached me about how best to manage a renovation. And Rena, I'm not sure whether you manage any 2-lot schemes, but I'm sure you've had some experience of them in your time as a strata manager. Those small schemes often have the biggest problems.
Yeah, I've only actually been asked to, I've been asked to manage them, but I try not to. But I've been doing a lot of consulting actually, because I think sometimes they just need that, like one party needs that help.
Yeah, so they, unfortunately, when there's a problem in a 2-lot scheme, a dispute, a personality clash, because there's only 2 owners, they are very hard to resolve, often becoming tractable. And of course, if you have meetings and you're trying to get something done, you can have a deadlock very easily if the unit entitlements, as they usually are equal.
Yeah,
so I do get involved in these situations, sadly, where there's NCAP proceedings or disputes in 2-lot schemes. But this one was a little bit more positive, and that's why I've listed it as a win. This owner's recognised that they want to do some renovation work. They've looked at the bylaws, which is simply the model bylaws from the 96 Act. They have no other real bylaws. They've got obviously the strata plan that shows where their boundaries are. And they've said, well, we want to do a bathroom, a kitchen. We want to remove some walls. We're obviously going to affect the common property. So we're going to need some kind of a bylaw. But in the meantime, is there a way, because we're a 2-lot scheme, is there a way that we can make very clear that each owner is responsible for the common property that is immediately adjacent to their lot? So, for example, can we say that the waterproofing in the bathrooms is the responsibility of the owners, that the ceilings, that the floors, that the laundry, the tiles, if there's ever a problem, if there's ever a leak, it's the responsibility of the lot owner, which kind of makes sense because we're in a two-lot scheme. We're not really affecting the other. We're not really paying levies. We pay an insurance premium for the building insurance, which we must have under the Act, that particular type of policy. But can we achieve this separate togetherness, if you like? And I've said, yes, you can. And I think you do that by way of a bylaw. So we know in our Act we have this ability, which we've always had, for the owner's corporation to specially resolve that it will not repair or maintain a specified part of the common property. And that's now in our Section 106. Used to be Section 62(3). It's 106(5) or something like that now. An owner's corporation has always been able to remove its obligation to repair or maintain a specified part of the property, but only if it will not affect the safety of the building or the structure of the building.
Integrity,
Yeah. So how do you ensure that it's not going to affect safety or structure? Well, you pass that responsibility on to the lot owners. So if you say the owner's corporation is not going to, for example, deal with bathroom membranes in this two-lot scheme, then you must also have a bylaw whereby the lot owners take responsibility for dealing with their own bathroom membranes and provide their written consent to that. So this particular lot owner has now asked me to draw up that all-encompassing bylaw. That my short summary of it is that it makes the lot owners individually responsible for those parts of the common property that are immediately adjacent to their lot, and we'll set those out with some specificity. And each lot owner consents to that, and away they go. They're able to then forevermore, until that bylaw is amended or repealed, look after their own little part of the world.
That's a great idea, Amanda. I think it also minimises so many future disputes between existing and other owners. What about obviously with the annual fire safety statement, even though a two-lot scheme would have very minimal fire safety equipment like, say, smoke alarms and fire doors and potentially some exit signs maybe at the back, I don't know.
Yeah.
So obviously that would still be under the owner's corporation's responsibility since it has to submit the annual fire safety statement to council and not individual members.
Yeah, we probably wouldn't deal with anything that relates to fire safety, and we'd only be covering things that we specify. So the things that I thought of so far was obviously that waterproofing, original tiles and internal walls where they meet the floor, because where you're removing an internal wall, where it meets the floor or the ceiling, you're going to be affecting the common property.
Exactly.
So floors, ceilings.
What about windows?
Yeah, windows. Yeah.
But what if they then change, like, obviously with a two-lot scheme, you want that uniformity, Amanda, and then architectural integrity. I mean, wouldn't you want the owners corporation to still have control to make sure that there is that? Or because one person could make it like louvers, and one could have
true. Yeah.
Like
well, that's gonna be a matter for them, I suppose. I'm not sure that they would be too worried. I haven't been out to see the building, but if you think about it, why is it any different to, say, a duplex that is not strata title or a semi-detached residence that is not strata title? And we have plenty of those in Sydney, and they each look completely different to each other. They're attached, but they're different properties.
I know that, but I think with a duplex, it's a bit different because duplex has that uniformity that you can tell when there's a duplex because they have that similar.
Yeah, or some people like
the
to
one
paint
building, but one lives
colours.
Upstairs and one lives down. That's how I sort of look at it.
Yeah, or you have one next to the other.
Yeah,
and
side by
maybe
side.
One
I've
wants
seen
to paint theirs orange, and the other one wants to.
Yeah, but
paint
I've seen those, and it looks like. There's one down here in Rose Bay, and one side looks like nice and modern, the other side looks like, oh my god! To me, it's like. You wouldn't want to, I don't know, I just think it's, in other cities in the world, especially like say in the UK and Ireland, there's far more uniformity of architecture than there is in Sydney. I mean, in Sydney, it's a real hodgepodge.
Yeah. Well, it might be something that you specify as long as it doesn't affect the external appearance of the building.
Yeah,
so,
exactly.
Yeah.
I mean, you can change as long as it's within keeping so that, like you have in community associations where everything, has to maintain a certain look. Yeah. It does affect the value, actually.
The external appearance, street
it doesn't matter because sometimes people won't buy in if something looks marginally different to their lot. It can affect the sale of that. Like the person that's done the right thing and kept it architecturally the same, but the other person hasn't, and they're trying to sell, and then they say, "Well, I don't want to live in a building where someone else above me looks like the poor cousin, etc."
Yeah, for sure. And then we come back to things like washing on balconies and all the external appearance stuff. Yes.
Yeah.
All right. So, I can give you an update on how the wording of that bylaw
Yeah.
pans out, but I thought that was a really good idea. And anyone who is in a two-lot scheme,
it's a great idea.
it's not always doom and gloom when you buy into these schemes to go, oh my gosh, I didn't realize it was strata and I didn't realize my neighbor was going to be a pain in the neck. There are ways, and often, I think you have had this question before as well, Rena, often these two-lot schemes want to get rid of the strata structure and become completely separate, but that's a matter for the local council, and councils generally, in my experience, do not facilitate that kind of a change because of lot sizes or whatever it is that's in their planning instrument. So how do we achieve some independence, some autonomy without having to make those planning changes? Well, bylaws are always a good instrument for that.
Every time I walk past a duplex, I always think, unless you own both of them, don't buy into one of those.
Yeah, I kind of agree, I have to say. Okay, well, awesome. That was a fab episode for our January 2019. Lovely to be getting right back into it.
Yeah, it's just very strange about it to be writing 2019. I keep writing 2018.
We'll get there. We always do.
Yeah, you do. After the first few weeks, it sinks in.
Yeah, exactly. All right, well, have a great week, Rena. I'll catch you next time.
You too, Amanda.
Okay, bye.
Okay, bye.
Thank you for listening to Your Strata Property, the podcast which consistently delivers to property owners reliable and accurate information about their strata property. You can access all the information below this episode via the show notes at www.yourstrataproperty.com.au. You can also ask questions in the comments section, which Amanda will answer in her upcoming episodes. How can Amanda help you today?